Week 3 of the dissection of Mark Herrmann's The Curmudgeon's Guide to Practicing Law. How to discuss a case. Here are all the things you need to mention every time you discuss a case in a memo or a brief. Who sued who? We need to know what this case was about. Who was the plaintiff? Who was the defendant? What was the trial court's holding? Mention what it did specifically. Did it affirm? Did it deny? Did it enter judgment in favor of someone, etc.? What was the appellate court's holding, if the case was appealed? Mention whether it affirmed, reversed, vacated, or remanded. After that, you say whatever else you think is important about the case. Also important to note is how persuasive your case is going to be. In order of persuasiveness, here are the types of cases you can cite from. Cases where the trial court did what your opponent is seeking and the appellate court reversed. Those are the most persuasive because trial court judges do not like to be reversed. And so this will dissuade them from doing what your opponent is looking for. Then there are cases where the trial court did what you're looking for and the appellate court affirmed. Those give the judge the sense that if they do what you're asking, they'll get affirmed. Judges like to be affirmed. Finally, there are cases where the court merely discusses an issue in dictum. That's non-legally binding theoretical conversation for judges, basically. In cases like that, what the judge discusses is not necessarily actually the law, but it may be persuasive on later judges tackling the same or similar problem. That's everything I got from the Curmudgeon's Guide on how to discuss a case. I hope you found this helpful. And if so, I hope you'll tune in next week for more on Mark Herrmann's The Curmudgeon's Guide to Practicing Law. Until next time, have a good one.